Welcome everyone online to this Garden Court seminar on access to education for migrant children. Thank you for joining us on this beautiful day. And if you're watching the recording at some later date, thank you for watching then. We are looking this afternoon at the barriers that migrant children face in accessing the support that they need to thrive in life, in education, in housing, and in wider support. And most importantly, we are looking at what we can do to challenge those barriers. My name is Nicola Braganza, and I'm a barrister at Garden Court, and I will be chairing the seminar. And I am absolutely delighted to introduce to you our four excellent expert speakers. We have Elaine Sheppard, Clare Jennings, Ollie, Persey, and Connor Johnston. Elaine will be our first speaker. Elaine will speak to a view from the frontline. Elaine is an education casework manager from Love to Learn, and she has worked in the inner London voluntary sector for several decades in community work, housing, campaigning, and family support. All of her roles have involved campaigning for improved public provision and access to services. She's worked with children and families for 25 years and is currently casework manager at Love to Learn, which is a project of the Catherine Lowe settlement in Battersea. In Love to Learn aims to increase access to education for refugee background children and young people. After Elaine, we then have Clare Jennings, and Clare will speak on free school meals and the Pupil premium. Heading up Matthew Gold and Co.'s public law and community care practice, Clare has over 10 years of experience representing individuals and NGOs in public law challenges. Her team was the winner of the 2021 Legal Aid Team of the Year Award at the Lallies, and has also been shortlisted for the Access to Justice Award and Small Firm of the Year at this year's Law Society's Excellence Awards. Clare was the winner of the 2016 Legal Aid Lawyer of the Year Award in the Children's Rights category for her work acting for migrant children in public law challenges. She has a wide breadth of experiencing in challenging state decisions and particular expertise in judicial review challenges concerning migrant rights and criminal justice matters. She also has considerable experience in challenging the exclusion of asylum-seeking families and those with no recourse to public funds from statutory support schemes such as free school meals, early education provision, and pupil premium. Ollie Persey, the first of our barristers of Garden Court, will speak to special educational needs and disability provision and the school inclusion project. Ollie has a busy educational practice. He frequently appears in the SEND Tribunal, Special Educational Needs and Disability Tribunal, on education, health and care plan appeals and disability discrimination claims under the Equality Act. He's currently instructed in a number of appeals to the Upper Tribunal on complex questions of equality law. He has particular expertise in challenging discriminatory treatment of racialized and SEND children, including unlawful school exclusions. And he is actively engaged in campaigning and policy work to address discriminatory treatment of marginalized children. He's on the steering committee of the School Inclusion Project, and he's also a committee member of the Education Law Association. And then last but not least, we have Connor Johnston, also barrister at Garden Court. Connor specialises in housing, homelessness, asylum support and community care law. He works on behalf of migrants who are not eligible for mainstream support, and he was recently instructed on behalf of Shelter intervening in the case of Nicola and Brighton and Hove Council, which dealt with the provision of accommodation by local authorities during the pandemic to persons with no recourse for public funds. He's a volunteer advocate at the First Year Tribunal Asylum Support with the Asylum Support Appeals Project, and he is currently working on the forthcoming Migrant Support Handbook for Legal Action Group. And so before I ask Elaine to begin, I'm just dealing briefly with housekeeping. At the very end, we'll have a Q&A session. So if you could put your questions into the chat box, and I can then pick them up and put those questions to the panel. And very finally, to remind you all that this is being recorded. And so we'll make available the recording and the slides very shortly after the seminar. Thank you. So now to Elaine, please.
Hello, everybody. I'm Elaine. I'm the Casework Manager at Love to Learn. I describe us as a small but lively project, charity funded, and we support refugee background children in Battersea in London. So I've been asked to give the frontline view, and I do want to, my disclaimer is that this won't be a representative view of need. It's more about the communities that we work with and the needs that they present. We're a project of the Catherine Lowe settlement, which is a big community centre, which has been going for a long time and puts this kind of right in the heart of the Battersea community. We have a big ESOL programme in the centre as well as an elders project. So as Love to Learn, we've been operating for about, actually more than 15 years, I'm told, developed in response to the needs of the large Somali and Eritrean communities in our neighbourhood. And we also work with more recent migrants from Afghanistan, Iran, Syria, and other countries. The other things we do in our project is provide after-school homework clubs for more vulnerable children, both primary and secondary school. We have a big programme of GCSE support. We have holiday activities. We have a mentoring programme where volunteers support young people in their own homes with their education. So that's the kind of context in which we do the casework. The other important thing is that we run parent workshops. We've kind of developed our programme quite a lot over the lockdown period to keep parents connected, supporting each other. And we use them to provide education, provide information about education, but also about parenting and other health and wellbeing support. So in casework, we support about 100 children and young people a year. This is the children that are living with their families. We support them around the full range of education issues. A higher proportion are from the longer established communities, the majority of whose children were born in the UK, and 30% are newer arrivals. So there are commonalities. It's a varied group, but common, very relevant disadvantages around education, particularly around their parents' level of English. We also work with 15 to 20 unaccompanied children and young people a year, particularly those newly arrived from Eritrea. This is in partnership with a school in Wandsworth called Southfields Academy, which has a long-established international group. They support newly arrived young people in years 10 to 13 with additional English language and welfare support. Our small team of 4 part-time staff, including Somali and Tigrinya speakers. And on average, about 70% of our work is done in the same language, which is a very relevant point. So I wanted to, just before I start to talk in more detail, just to remind you about some of the pressures that kind of make up the context in which we're trying to improve children's access to education. So especially pressure on local authority and school and social care budgets. So, and also increased academisation. So many local authorities, for example, used to have English as additional language teams advising schools, and they used to have a much bigger education welfare function than they do now. Our unaccompanied children are very dependent on hard-pressed social workers, and in our local authority, it feels like all provision is very rationed at the moment. You can win things, but only on appeal quite often. So schools feel less accountable, and children with additional needs, including language needs, feel less well served. Unfortunately, we find busy Senkos sometimes acting as barriers to resource rather than gateways. Discrimination feels less challengeable when resources hard come by. I think we need to kind of bear that in mind. And then from the parents' point of view, parents always feel on their own when they're challenging a school. And it's so much harder when you don't understand the system and your English is basic, when you're trying to fit in and not stand out. Unfortunately, racism is alive and well out there in education, as everywhere, which makes it necessary to challenge racism if you have the energy, but also making it harder to challenge. So parents and young people who've not been taken seriously are more likely to be when we show up with them, as you can imagine. And also without our language input, their voice would often not be heard at all. So around admissions, we provide a lot of help with admissions, including just standard admissions to primary and secondary schools, appeals, in-year applications for new arrivals. Some children can be out of school for long periods, and by which I mean months, which makes a big difference to education on top of the huge upheaval of moving country. So there are huge difficulties we find in just getting through to the council by phone, slow replies to emails. And these are all things that parents are trying to negotiate themselves. Over the last period, it's been very difficult to get through to our local People Services department directly. And just last week, for example, I had 2 20-minute waits to get through to somebody in another local authority, and was left quite frustrated by quite a patronising response. And I'm somebody who knows quite a lot about the education system and trying to negotiate what was a slightly complex situation. So another issue for admissions for us is the in-year transfers into years 10 and 11. I'm sure everybody else would have this as well. We find that they're practically impossible in our local authorities. The council will tell you that your application has been unsuccessful and advises you to ring around schools. But schools are not accepting children most often into years 10 and 11. The local authority will often say to you then that the PRU is the only option. So an example is a young person in year 10 who we supported, who was withdrawn from a school due to bullying related to a health issue. We rang every secondary school within travelling distance without success. The local authority said the PRU, the family were very concerned about him going to a PRU given that he'd been bullied. In this case, through our links with the Battersea Secondary School, we were able to get him a place by restarting year 10, essentially skipping a year. In another case, a parent gave up and paid for their child to go to private tuition rather than go to a PRU. This young person had been sent to school in America for a while because he was getting in with a group of young people who were involved in gangs. The schooling in America didn't work because of COVID, and when he returned, his previous school wouldn't take him back. In other instances, places are offered by schools, but it can take a long time for the local authority to confirm. Luckily, we do have contacts in local schools, and they can sometimes bear fruition. Around exclusions, we do a lot of what I would describe as low-level exclusion work. Common is a parent contacting us to say their child is getting detentions all the time. The parent is being told negative things at the school gate or by phone, or they're just watching their child get more demoralised. So we get involved, seek a meeting with the teacher or the head of year, and we do usually manage to turn things around, just from asking for the detail, presenting particular needs that we know about in that family, asking what support the school is providing, making sure the young person has a voice. I'm going to give you an example. So I've been supporting this is not such a good example, sort of not such a positive example. I've been supporting a parent of a child originally in year 3 who was threatened with exclusion, permanent exclusion, and whose mother was blamed for her parenting, felt blamed anyway. And this is despite the fact that the parent had older, higher achieving children in the same school who had no issues, and her flagging her own concerns about her child's needs. So, as is often the case, we and the parent, rather than the school, identify that there's probably a need that needs to be addressed. And following referral to CAMS, the child was diagnosed with a high level of ADHD. We then, from the beginning, we were asking for an educational psychology assessment, and we had a considerable fight for this. I think it came in the end a bit over a year after we'd started requesting it. I have to say that educational psychology support seems to be very rationed at the moment. Plan of provision wasn't put in place until year 5. Remember, we started in year 3. Then year 5, it was a difficult COVID year, but there were times the schools were open for a bit and very little support was put in place. Now the young person is starting year 6, severely disadvantaged. So he's obviously been disadvantaged all the way through primary school. We have formally now complained to the head teacher, but this is a case that I feel particularly badly about, that there must have been something else I should have done. So just to talk a bit about discipline and academies. So academies quite often do pride themselves on their expectations of discipline, and some parents are very happy with that. Some feel that it can be too strong, but many young people struggle with the behaviour management processes, which can be very quickly escalated, in my experience. So one academy we know specifically requires children not to make many facial expressions or sounds. For example, roll their eyes, click their teeth, or even sigh. Those expressions resulting in quite a quick escalation to the head teacher. So we know young people have actually got used to being in detention almost every day, often with long periods of time in isolation as well, and it's called isolation. I've also witnessed very disrespectful approaches by behaviour leads in schools to parents. For example, in one meeting I attended with a parent, the teacher started the meeting with, "Your children are insubordinate, rude and disrespectful. They're facing permanent exclusion." And this was a relatively new parent to the school. So one of these children, this teacher was talking about, has just turned 14, who has just turned 14, has subsequently been diagnosed with autism, ADHD, and a significant learning disability. So in this case, several schools have missed many opportunities to consider her needs and ensure that they were properly assessed. Here, we had a 2-year fight for a BP assessment. So now we've requested an educational health and care needs assessment. As you know, those processes take long, and we can imagine what years 10 and 11 are going to be like for this young person. She's in fact the second teenager that we've supported through very late diagnosis. And obviously this is a tough time as a teenager to find out that you have additional needs. In the other case, the young person continued to be excluded despite her diagnosis, right up to the time she left the school. She's now in a school for children with special needs, which she originally fought against, of course, but is actually finally happier, and I'm sure she's accessing more education. So EHCP processes are complex, as people know. There's no translation of EHCP plans in my experience, and these are incredibly detailed documents which are essential when you're going to hold provision to account. There may have been interpreters at the meetings in which the plans are drawn up, but this doesn't mean the parent has really had time to consider and fully understand, let alone challenge the decisions that are made there. So this is part of our role, is supporting parents to understand, but it's incredibly time consuming. So in our experience, some schools are better than others in providing interpreters for meetings with parents. Often this is inadequate. For example, a member of staff who speaks the language will be brought in, or in one case, which we did challenge, the interpreter was a senior student. At least one school has told me that they don't provide interpreters. Unfortunately, we as a project end up compensating occasionally. We really try not to, but agreeing to meetings that we will interpret in order to speed things up as needed. So permanent exclusions have been lower in the last 18 months for obvious reasons. The main one we dealt with last year was a young man in year 12. He was involved in a silly playground incident, but he had no previous exclusions. He and his family were invited to a formal looking meeting and told he'd been permanently excluded. The parent then phoned us up. Oh, he was also told to start looking for other schools. So nothing had been given to this parent in writing. So we talked to Alex at Just for Kids Law, who was very helpful, and advised us to definitely seek legal aid, legal support. We went through the process of helping the parent to get legal aid. And after a solicitor's letter, he was accepted back into the school. So it was poor treatment and procedure and a huge amount of anxiety later. So we were previously involved in a MAG case where a young person was permanently excluded from school in year 8. This was overturned, but the school refused to accept her back. For the next 3 years, the local authority the local authority maintained that Prue was the only answer for her, and effectively blocked applications to mainstream schools who said they had places. Her mother was adamant she didn't want her to go to the Prue. The Fair Access panel backed the council officers and made no contact with the young person or family. And in fact, this young person had references from placements she'd done and an NHS apprenticeship and other things which talked about her behaviour being very good. So it was only after local councillors got involved that she was finally admitted to college last year after 3 years. So actually that case, we don't claim credit for. It was a family friend who really helped her, and I provided some level of backup and got some legal advice as they needed. Okay, my last bit is about unaccompanied asylum seeking children, because we do work with these, and they're obviously some of the children in most need. So we often don't stop to imagine being a young person arriving in a new country on your own, traumatized by your journey, which in our experience on average takes 3 years, worried about your family who may have debts related to paying for your journey. You've had to live on your wits to prevent yourself being arrested crossing borders. You've had to deal with smugglers. You've had high levels of physical hardship, if not injury. You've probably witnessed death. So you have little English, and you're thrown into a care and education system that treats you as a child. Good thing, they are children. But obviously that also has its complexities. So you have no certainty about your immigration status and little understanding of your rights. You're busy processing all of this. So the young people we work with are really lucky to have the Southfields International Group. As I said, they get additional language and welfare support there. We work mainly with young Eritreans through our team member, Mary, who speaks Tigrinya and Amharic. She helps in class, but she mainly supports the young people with wider issues. So this is a charitable funded addition to the work of the school. The biggest benefit of the work, I would say definitely, is about language and cultural support, this same language support from someone of Eritrean background who is passionate about the young people getting the help that they need. They might tell their stories to other young people, but they're not telling them to many people, and they are sometimes telling them to her. They feedback that the same language support is what makes a difference to them. So at Southfields, Mary is sometimes called on to mediate between teachers and students, and she can explain culture clashes. For example, young people in trouble for not looking their teacher in the eye, when in fact it's disrespectful to do that, to look your teacher in the eye in the Eritrean culture. Another young person in trouble for laughing when he was shouted at, and when they got to the bottom of it, it was just that he was so anxious that he was really laughing, and it was a response to nerves. So these young people all have social workers and foster carers, but these can vary hugely in quality and obviously capacity and perhaps motivation in terms of maintaining supportive relationships. So we do a lot of the support around problems with foster carers and social workers, as well as other practical things. Crucial support, for example, around a young person who got pregnant. There was a huge array of children's services support in place as well, but it was Mary's input to talking to that person, including in the evenings sometimes, that really helped to get her through that situation. We have problems. We find there are problems with solicitors quite often just not doing what they could be doing, and young people not knowing that. Unfortunately, we've built up a good partnership with solicitors at Islington Law Centre. They help us to push forward delayed refugee applications, for example. And some of our most satisfying work this year has been family reunions. We had a huge task, Mary had a huge task with the solicitor trying to get a 14-year-old sister of one of our service users out of a prison in Egypt and reunited with her brother here. And she did that successfully. We've had a father come to join his son. We've had other siblings arrive. So I don't need to tell you about the impact of these things on education. I'm conscious I've given you some of our worst cases, but every case involves a child trying to make their way in the world. There are clearly injustices in the system that need addressing. We do little bits of good work or lots of good work. But I've said this to Ollie before, where we're still failing young people is that we probably don't always get to that next stage, the higher stage of challenging, partly just primarily through just being too busy. So we welcome concrete help. Hopefully this is where some of the rest of you come in. Thanks very much.
Great. Thank you, Elaine. We did actually have one question in the chat. I know I said I'd leave it to the end, and I think you've pretty much answered it. And the question was, there would appear to be numerous unlawful acts described in respect of admissions. Do you refer to solicitors for legal aid advice? I think you did say that you're working with Islington Law Centre and you refer on others.
We do, yeah, we do. I'm not convinced that we do it enough, particularly around admissions. Oh, certainly around the PRU situation. Yeah, we did. Legal advice was sought. So we do when we get to the end of anything else that we can do.
Excellent. Well, thank you. I mean, it's quite depressing to hear a lot of it, but equally very heartening, at least that they have you and the difference that you've been making. So now turning to Claire. Claire, can you speak to free school meals?
Yes. Hi, everyone. I'm Claire from Matthew Gold & Co. I am going to hopefully share my screen. Hopefully that will work. Yes, so my firm has, over the last couple of years, done quite a lot of litigation in relation to access to kind of education, well, not so much education provision, but knock-on services for migrant children, including free school meals, pupil premium, and early education for 2-year-olds. So I was just going to give a quick overview of the kind of cases that we have been doing, and why there is a problem for children from migrant families accessing this kind of support. So one of the major problems is that the free school meals eligibility criteria is frequently used as the gateway to accessing other support. And that criteria is set out in the Education Act. The problem this causes for children from migrant backgrounds is that the eligibility criteria requires their parents to be claiming welfare benefits. And so many migrants are excluded from claiming welfare benefits. Either they've got a no recourse to public fund condition, they're just here unlawfully, they're asylum seekers on asylum support. And the consequence of that is that children from some of the most financially deprived families for whom these schemes are actually meant to help are then excluded from support. So we've done quite a few cases around these kind of exclusions from support. Last year, some of you may remember that when schools closed with the coronavirus, the government announced a coronavirus free school meals voucher scheme to help those children who would have been getting free school meals if they were in school, who were at home. Again, the problem was it was the same eligibility criteria for free school meals. So children whose families had no recourse to public funds were still excluded. We sent a pre-action protocol letter, a judicial review pre-action protocol letter challenging that criteria on various grounds. And actually a week later, the Department for Education responded to the pre-action letter agreeing to extend eligibility to families with no recourse to public funds, which was, I hope, a help to children in those families during the crisis. We then had further proposed claims for judicial review because whilst they extended the scheme, the income threshold for eligibility was actually lower for the NRPF families than those who were claiming welfare benefits. I don't think that was necessarily deliberate by the Department for Education, but more not thinking things through properly. But it took a few more pre-action letters before we got parity. We then decided that the time was right to have a go at challenging the eligibility criteria for free school meals in the Education Act. I think there might be quite a few lawyers watching. Obviously, challenging primary legislation is not easy, but we thought now was the time. And so we again threatened judicial review on the basis that the criteria was incompatible with human rights. And that claim never got issued because the response we received was that they were going to review the eligibility criteria, and the temporary extension that they'd already agreed would then be extended until that review. They had said that they had anticipated the review being autumn last year, but as far as I know, there's still been no review, and the temporary extension has continued. So we're obviously letting it continue. We have also had litigation in relation to the pupil premium. Many of you will probably know that pupil premium is money given to schools to help deprived children, disadvantaged children, and it is paid for each child who is receiving free school meals or has received free school meals in the last 6 years. And it can be quite significant sums for schools, who then have discretion as to how they spend it, as long as it's in accordance with the purpose of the scheme. The problem that arose was that the Department for Education's guidance, the way that schools get their pupil premium is essentially they fill out a census telling the Department for Education how many kids are receiving free school meals or did. And the guidance on how to complete that told schools not to include the details of children who were getting free school meals under the extension for children with no recourse to public funds. So that would then mean that in turn, pupil premium funding wouldn't be given. We did issue proceedings in relation to that, although it was on a protected basis. And quite early on in that litigation, the Secretary of State agreed to implement an additional process for schools to report on those families, on those children getting free school meals under the extension, and that pupil premium would then be paid. Another similar scheme was about early education provision for 2-year-olds. And again, it was a scheme, it was meant to help children from disadvantaged backgrounds, but the regulations had adopted the free school meals criteria of claiming welfare benefits. And so it excluded children from migrant backgrounds. We actually brought 2 judicial reviews, and Central England Law Centre brought one as well. Our first judicial review was brought by a British child and resulted in eligibility being extended to the children of Zambrano carers or those with leave to remain subject to a no recourse to public funds condition. And what was one of the kind of points of learning we took from that case is the defendant were quite adamant that they weren't going to extend eligibility beyond the circumstances of the claimant. So in that case, initially they said, we're only going to extend it to Zambrano carers, and we were able to push them to extend it to families who had leave with an NRPF condition, because our client's mother was in the process of applying for such leave. And we took the decision to settle that claim, kind of take that extension, and then we brought a second judicial review on behalf of a non-British child whose family were in receipt of Section 17 Children Act support. And again, the defendant settled that claim at an early stage and extended eligibility further still. I won't go through in huge detail what kind of arguments we made, because obviously it will depend on the different scheme that is being challenged, whether it's in regulations, guidance, or like free school meals in primary legislation. But one of the consistent themes that we have noticed in this type of litigation, and we've also done it in other contexts such as Healthy Starts, which is about vouchers for babies and young children, is there often doesn't seem to have been a deliberate intention to exclude these children from this kind of support, it's been more, it appears to us it's been more that no one's ever actually thought about it. So when we've gone through, and there's often quite a lot of it, the background to the scheme, all the background documents, impact assessment, policy reports, all of that, at no point, there's nothing in the publicly available material, nor in any of the defences I've seen, that evidences any consideration whatsoever to have ever been given to the fact that adopting this particular eligibility criteria will actually exclude some of the most disadvantaged children, who are precisely those the scheme is meant to help. So if you're facing this kind of challenge, that the kind of arguments we've had have been about whether they've had regard to material considerations, and about the impact of the eligibility criteria. And that has kind of run through all of the arguments we've made, because it then begins to go to the rationality of the criteria adopted, and we made discrimination arguments, and of course the extent to which the discrimination can be justified. It's hard to justify it if actually you didn't even realize that this was going to be the impact and you never actually meant it to have that impact. So those have been the kind of arguments that we've been making, and so far all of our cases have settled at an early stage in the litigation. And I wonder whether it's actually perhaps because there wasn't a deliberate intention to exclude migrant children. So I suppose I will leave you with the thought that if you're looking at a scheme that excludes migrant children or children from migrant backgrounds, because their parents can't claim welfare benefits, then you may well have some kind of grounds for challenging those kind of decisions. So I would be looking out for that type of thing. So that concludes my overview of our free school meals and pupil premium litigation.
Thank you, Claire. That was excellent. Really interesting to hear the successes that you've had and how early on you've had them in the life of the litigation and the patterns that have emerged. Thank you. Ollie, you're next.
Thanks very much, Nicola, and thank you, Elaine and Claire. My presentation is going to be a lot less interesting, unfortunately. It's a nuts and bolts run through of special educational needs in 15 minutes. So obviously in a lot of detail, and hopefully I've picked up some of the key points that are relevant to migrant children. I would note that I'm speaking about the situation in England. There's a different statutory scheme in Wales. So we'll be sharing slides, but I wanted to include a load of key resources if you're approaching special educational needs law for the first time, or even if you're not. In particular, I would like to flag the Disabled Children Illegal Handbook, produced by LAG and available to download for free on the Council for Disabled Children's website, which is a hugely valuable resource. So what are special educational needs? Well, I've put the definition on the slide, and it's a learning difficulty or disability which calls for special educational provision. What do those terms mean? So a learning difficulty or disability is the definition from the Equality Act. Learning difficulty is a child of compulsory school age, which means up to broadly 16, or young person up to 25, who has a significantly greater difficulty in learning than the majority of others of the same age, or a disability. So it is important to note, particularly in the case of migrant children, that there is a carve-out or a specific reference to having a different language being a barrier, and that not constituting a learning difficulty. So unfortunately, in my experience, lots of local authorities use this as a way to get around not having to do an educational EHC needs assessment because they say, look, there's no evidence of your child or young person having a learning difficulty or disability. It's simply because they haven't learned English yet. So you fail at this first hurdle, I'm afraid. No assessment. That is briefly what the definition of provision is. It's always worth looking to the SEND Code of Practice to supplement what the statutory and regulatory framework is. Code of Practice is quite helpful in this regard about what special educational provision should look like. So I've flagged two paragraphs in particular and put in bold the key points. The key point here is that special educational provision needs to be effective, practical and effective provision to meet need. That, in my view, means that it needs to be culturally sensitive provision, and given the requirement for education, health and care plans to be specific and quantified, you can have provision in the section F, which is the provision section of an education, health and care plan, which ensures that that provision is accessible to a child who has a language barrier or other complex needs that arise from their immigration status. So I would also flag what's in 5.33 about the focus on the individual family's needs. So you go beyond and look at the language barriers or other needs that the family might have, which are relevant to whether the child can access education and progress. Special educational needs properly should be conceptualized as a barrier to education. Provision is input, for example, speech and language therapy, one-to-one support, whatever it might be, to help overcome those barriers that derive from SEN, special educational needs. But the way those provisions are put in place needs to be culturally sensitive and effective. So I'm not going to go into healthcare and social care provision because I have 15 minutes, but you will have the slides. I wanted to flag that there is a duty on the local authority to identify children and young people who may have or have special educational needs, and children or young people with a disability. And that duty is to some extent treated as a dead letter by a local authority unless a referral is made by a parent or a school. And that in practice proves more difficult for some migrant children who, for the reasons that Elaine very clearly set out, their parents might not be able to navigate the system as easily as others, and their school might simply dismiss their needs as relating to not being able to speak English as a first language, and therefore don't make a referral. So we have a problem there in practice of getting to the first stage of the education and healthcare needs assessment. I wanted to also flag about who's responsible for ensuring that an EHC needs assessment takes place, provision is met, etc. And it is the local responsibility. It is local authority in which the child or young person is in. It's a geographic test. So, duty to secure an EHC needs assessment. I just wanted to set out just how low a bar that is and why it's totally impermissible for a local authority or anyone else in the system to try and prevent that from taking place. So first of all, as I set out in the guide, set out earlier, the guidance makes clear and the regulations make clear that actually, yes, there's an exception for language, English not being a first language, but it's solely English being a first language. If there are potentially other needs, then an assessment has to take place. And if you look at that final line, if an LA considers that a child or young person has or may have SEN, and that it may be necessary for special educational provision to be made for the child or young person, then they must secure an education healthcare needs assessment. That's a low bar to get over, but is often used, in my experience, as a way of preventing people from accessing stage 1 of the process of getting an EACP. Then the next stage is to secure an EHCP. So once an assessment has taken place, if it is deemed to be necessary for special educational provision, and it is hoped that an EP assessment, etc., would be culturally sensitive and have the nuance to recognise the distinction between barriers that arise as a result of language or barriers that relate to SEN or disability. If it is necessary, then the LA has a duty to secure that EHC plan is prepared and maintained. Now, the SEN Code of Practice is really helpful for setting out exactly what happens at what stage and provides more detail than the regulations. So if you're navigating this, in addition to the legal handbook that I mentioned, it's really important to go to the SEN Code of Practice. And helpfully, there's a really neat flow chart about what should happen and when. And it's always disconcerting to see delays in these processes. And those delays are subject to challenge by judicial review if they are unlawful delays. So briefly, what does an EHCP actually look like? This document that you get that provides enforceable rights. Well, the key sections are generally for the purpose of special educational needs, and note that I didn't say health and social care in that, are sections B, F and I, which is the special educational needs section, which need to clearly identify what the child's SEN or disability is. The special educational provision is the support that is required to overcome those needs and support the outcomes that are desired. And then section I, which is the placement that the child will have for their education. So the duty to secure special educational provision is an absolute duty. And again, if this is not being respected, if this is being, if an EHCP is being breached, that is challengeable by judicial review. Briefly, the local offer is a publication of the provision it expects to be available within a local authority's area. And it's a useful resource to look to when you're trying to advise children with SEN or SEND about what's available in your area. There's also a duty on the local authority to publish it. So, common issues that are facing migrant children and SEND provision. As I've mentioned, needs dismissed as arising from not having English as a first language, when actually the test is solely as a first language, and the SEND Code of Practice notes that special care is required when assessing whether a child who does not have English as a first language might need extra support. Inaccessible information. The SEND Code of Practice repeatedly refers to the SEND Code of Practice to information needing to be accessible. That, in my view, requires translations so that all children can access that information. Failure to do so, again, would be JRable, in my view. Lack of effective participation. The child's voice or child or young person's voice has to be heard through this. There's a statutory duty in relation to that. But if there's not, if it's not heard, which can often happen if there's a language barrier or there's gatekeeping stopping them getting to the first stage of the EAC process, that simply cannot happen. Lack of cultural sensitivity in the needs assessment and in provision, as I discussed earlier, a real problem in that, for example, you might have a speech and language therapist that has put in place that doesn't have the language skills to be able to provide that speech and language therapy. Now, that's not going to be effective provision, and the key focus of the SEND Code of Practice is on efficacy. Elaine mentioned the issue of no translation of EHCPs, and Elaine mentioned that to me a few months ago, and I'd not seen it, and I have since seen that a couple of times. That, in my view, would also be unlawful, again, because of the requirement for accessible information. But the appeal right is vested in parents for children. Now, I'd consider that to be a frustration of the legislative intent of Parliament and a fetter on the ability of parents to appeal and challenge an EACP. And the appeal process is quite a complex one, involving negotiation and reworking of wording. If they could not access a translation of an EACP. So that, in my view, would also be unlawful. I'm conscious of the time, so I'm going to go very briefly through my next slides. Forums for challenge, well, you've got an appeal and you've got JR, and there's also mediation as a route. What can go to the tribunal is set out on that slide. I don't propose to go through it in any detail because the slides will be sent to you later. It's worth noting that if, obviously, as for anyone familiar with public law, if you've got an appeal right, it can be very difficult to judicially review because you've got an alternative remedies issue. So issues out of scope of Sen Tribunal are ones that can be delayed, that can be JR'd. So, for example, delay in the process, placement refusing to admit child, systemic or potentially a systemic challenge because the focus of the local authority of the Sen Tribunal is focusing on the child in front of them or young person in front of them. The health and social care provisions sections, the tribunal can only make recommendations. So in my view, that's not an adequate alternative remedy. And urgency can, although there is an expedition procedure in the Sen Tribunal, in my view, urgency of a situation can justify bypassing the tribunal in certain circumstances, even if it is within scope of an appeal right. Very briefly, legal aid, what's in scope, what's not in scope, preparing a send appeal in scope, and also advice in relation to EAC needs assessments. That's under the education legal aid contract. Representation at the Sen Tribunal is out of scope, but exceptional case funding is being granted where the ECF criteria is being met. That's still relatively unusual. An appeal to the upper tribunal comes back into scope, slightly bizarrely, if given that there's a lacuna of the representation at the Sen Tribunal stage. Then there's mediation, which is funded by a local authority, and then JR can be under the public law legal aid contract, or indeed the education legal aid contract. And that is the end of my slides. I very briefly wanted to flag the School Inclusion Project, which has just launched by Garden Court Just for Kids Law, the Law Centres Network and the Communities Empowerment Network, which aims to address systemic discrimination in the school system. We had a launch event 2 months ago now, and we've been signing up people to a Google group, which is imminently going live. We have about 300 people who are members of that Google group, and that includes frontline organisations like Elaine's, solicitors like Clare and others, and barristers at Garden Court. And the idea is to bring a forum both for policy exchange but facilitate representation. And Amy very helpfully has just put a link in the chat. Okay. So if you aren't members of the School Inclusion Project yet, you still have an opportunity to do so. And that finishes my presentation. Sorry for going slightly over.
Brilliant. Thank you so much, Ollie, for that really comprehensive outline of all the provisions and in practice how to apply them. Connor, handing over to you. Thank you.
Thanks, Nicola. So I'm going to tie things up by talking about suitable accommodation. The premise of what I've got to say is I think this perhaps quite obvious observation that suitable accommodation is the essential building block, or one of the essential building blocks, to effectively accessing education, not just for migrant children, but for kids generally. And I mean, I feel like over the years I've had too many of my homeless clients who have to spend, children in particular, who have to spend 2 hours on the bus to get to school and the same time back again, and 4 hours a day on public transport is leaving them exhausted. It doesn't leave them time to have breakfast. It means they are not getting what they should out of their education. With my asylum support clients, I've had too many clients who are in accommodation that is overcrowded or is in appalling conditions. And so you end up with children who don't have room to study, who can't sleep properly because they're sharing a room, 2 kids sharing a room with their 2 parents. So location of accommodation and the nature and quality of accommodation is absolutely fundamental to whether or not young people can get the educational provision they need. So that's really what I'm going to be looking at over the next 15 to 20 minutes. I'm going to focus on legal principles, but just bear in mind this sort of evidentially the backdrop to what I'm saying is that if you want to effectively challenge somebody's accommodation for whatever reason, the kind of evidence you are going to need is evidence from your client, from their school, from social workers, doctors, etc., environmental health department, setting out exactly why it is that their accommodation does not meet their current needs, why it's causing detriment to their education, to their health, etc. So that's the sort of ever-present practical backdrop to the legal principles that I wanted to talk you through. There are two aspects to what I wanted to discuss this evening. The first is the question of who's responsible for the provision of accommodation, and the second, once we've got through that, is the legal framework relating to the suitability of that accommodation that applies to each of those bodies. And responsibility is, for some of you, you may think this is quite obvious. You may be thinking, well, I know it's the Home Office who have to accommodate asylum seekers, for example. But the reason I want to take us through the main principles quickly is because I do think there are a couple of grey areas in this field, which I often get queries from about solicitors. So I just wanted to flag those. So with that in mind, asylum seekers, as I say, we know that asylum seekers are the responsibility of the Home Office under Section 95, and that there's a special definition of an asylum seeker, which refers to those who are not under 18 and who've made a claim for asylum that's been recorded but not determined. The first grey area with institutional responsibility arises from the fact that there is an extended definition of asylum seeker within the legislation, which is the third bullet point on this slide. So it actually encompasses certain failed asylum seekers where there are children in the household and they've been present in the household since before the asylum claim was rejected. So asylum seeker in this context actually encompasses though certain failed asylum seekers as long as the child was born before the claim was rejected and the appeal rights were exhausted. And the reason that is particularly important in this context is because under Section 122 of the 1999 Immigration and Asylum Act, there is a very clear demarcation of responsibilities between Home Office and local authorities. So local authorities are not permitted to provide assistance under Section 17 of the Children Act to any child or family where the Secretary of State is, or they're providing support under Section 95, or there are reasonable grounds for believing that she should be. So putting that together, putting that exclusion in Section 122 together with this extended definition, what it means is there are certain failed asylum seekers who are actually classed as asylum seekers. And as a result of Section 122, they are the responsibility of the Home Office and local authorities can't help. And quite often with these cases, I think that there is a temptation when they land on your desk just to see the fact, well, this person is a failed asylum seeker, so I'm pretty sure that must be local authority. Well, actually, it's a little bit more complicated than that. To decide who should be helping them, you need to work out exactly when it is the children were born in relation to the asylum claims. You need a really clear chronology of when the children were born, when the appeal rights were exhausted, to work out which body it is you're going to approach to say, please accommodate my young person. But to complicate this point, so the grey area within a grey area, the exclusion from assistance under Section 17 contained in Section 122 isn't an absolute exclusion on all forms of assistance. Assistance has this narrow definition, which is just accommodation and essential living needs. So if you've got, for example, a disabled child who is in a failed asylum seeking family who's in Section 95 accommodation, the local authority can still provide Section 17 support to top up what's provided. So over and above the accommodation and essential living needs, they could be helping out with disability related needs. So that's how we deal with asylum seekers. I just wanted to flag as well that I'm talking in general terms about asylum seekers. They are generally the responsibility of the Home Office, but recent arrivals from Afghanistan, I'm sure a lot of you are starting to see these coming through. The position, I think, is potentially going to be a little bit more complicated. A lot of those, such as the human rights defenders who are being brought over under the Home Office's resettlement scheme, are actually being granted leave to enter, and sometimes with recourse to public funds. Watch out for those cases, because my view is that those asylum seekers very exceptionally should actually be eligible for mainstream homeless assistance from the local authority. So that's asylum seekers. Unaccompanied asylum seeking children, that's the next cohort I wanted to look at. That's fairly simple. We all know, I think, that these are the responsibility of local authorities, social services. They're accommodated under Section 20 of the Children Act. Failed asylum seekers, again, this is the other potential grey area. They might notionally be eligible sort of on the face of the legislation, either for local authority help under Section 17 of the Children Act, or for support under Section 4.2 of the 1999 Immigration and Asylum Act. The position taken by the High Court is it's generally going to be Section 17 which should apply. It's not an absolute trump card, but local authorities can only justify refusing Section 17 support on the basis that Section 4 is available if it's been shown that the Home Secretary is actually able and willing, or can be compelled to provide it, and this is the critical point, that Section 4 support would be enough suffice to meet the child's assessed needs. And what Mr. Justice Mumby said in that case was that Section 4.2 support is sufficiently austere that local authorities are very rarely going to be able to justify a decision that is going to be enough to meet the needs of the child and the family. So general position, failed asylum seeking families, Section 17. I have never, it's theoretically possible that a local authority could pass the buck to a Home Office if they had carried out an assessment and found that the Home Office support exceptionally was sufficient to meet their needs. But I've never seen a local authority assessment which actually effectively does that. So practical terms, we're looking at local authorities. Other persons with no recourse to public funds, and I'm using that label in the broad sense. I'm using it to refer to people here lawfully with an NRPF condition on their leave. I'm also using it to refer to those who are here unlawfully who have no recourse to public funds as a result of that status. They're not going to be eligible for any kind of Home Office support, so they are also going to fall under Section 17. So that's where we are with institutional responsibility. So having decided who it is that is responsible for providing accommodation to your client, the next issue to address is what are the relevant standards on what that accommodation should be. So a bit of context before I launch into the various categories I've taken you through. Private accommodation in this country and a reasonable amount of privately rented accommodation and a reasonable portion of social housing is not especially high standard. I think we will all be aware of that. If we have a housing crisis, this is one manifestation of it. English Housing Survey that tells us that 7% of private renters living in overcrowded accommodation, 9% of social renters. So that's about 1 in 14 and 1 in 11 respectively are in overcrowded conditions. And this has been on the up since 1995. Conditions in which that people are living are, if anything, even worse. 2019, we had 4.1 million homes which failed to meet the fairly modest decent home standard. Within that, nearly a quarter of homes in the private rented sector failed to meet the standard and had category 1 hazards. So those are hazards that in broad terms are fairly dangerous under the 2004 safety rating system. The reason I'm giving you all this by way of context before I talk about the particular standards that apply to the different types of accommodation I'm looking at is that this is the backdrop to which decisions are made. It's well established in the asylum support context, in the homelessness context, that Home Office, local authorities, courts are going to look at the realities of the situation. They're going to look at the wider context in deciding whether or not accommodation is adequate. So you have to bear in mind that accommodation standards generally in this country are not especially high. So if you are challenging the adequacy or suitability of accommodation, you need to be thinking about why is it that what is it that takes your client's case out of the norm? Maybe it's a flawed decision-making process. Maybe it is because they are particularly vulnerable. Maybe it is because their conditions are worse. But that's the sort of mentality I think it's useful to approach these cases with. So with that in mind, let's start again with asylum seekers and look at the accommodation standards that apply to them. Well, any accommodation under Section 95 has to be adequate. So there is an express statutory requirement of adequacy. And the assessment of adequacy has to take into account a number of factors. So, for example, whether or not the accommodation is reasonable to continue to occupy. And that's something that requires the Home Office to look to the future. It means entails considering how long it is that somebody's going to be in the accommodation. So if they're going to be there for a long time, if they've been there for a long time, then something that might have been adequate in an emergency for a few days, a few weeks, may become inadequate. We also have the Reception Directive, the EU Reception Directive, Article 13(2) of which requires accommodation which is sufficient to ensure a standard of living adequate for the health of applicants. So this statutory concept of adequacy is informed by Article 13(2) of the Reception Directive. Now, of course, we've left the EU, we have a different legal framework, but the High Court in the recent challenge to the use of Napier barracks as accommodation has told us that the Reception Directive in this particular context continues to apply. So we're still using that threshold of whether or not the accommodation is good enough to ensure a standard of living adequate for health, which I think is helpful because it's a bit more of a black and white standard, which can be, I think, applied more readily than this more amorphous standard of adequacy. So those are the statutory considerations which we take from the asylum support framework specifically, but there are additional statutory considerations which we have to be thinking about in any case where we're concerned about the adequacy of our client's accommodation. We've got the duty under Section 55, the children's welfare duty, Home Office required to discharge functions with regard to safeguard and promote the welfare of children. And we've also got the public sector equality duty, which is particularly relevant when we're talking about migrant children, vulnerable migrant children, where they might have disabilities which are related to their educational provision. So in that case, public sector equality duty is going to require Home Office to have regard to a number of factors, such as need to advance equality of opportunity. The reason I flag these two particular statutory considerations is firstly because I think they are useful pegs to hang your hat on when you're trying to say to the Home Office, you have to consider this evidence as to why my client is not adequately housed and why their housing is undermining their ability to access education, or undermining their disability related needs. So it's your way into getting the Home Office to look at these points, but also because I don't think I've ever seen a Home Office decision letter which properly complies with these requirements. Look at that first bullet point. We know from the Nzola Meza case that what Section 55, or it's actually Section 11 of the Children Act in that case, which is the more general equivalent to Section 55, requires public bodies to identify the particular needs of any children collectively, individually, and have regard to the need to safeguard and promote them when making any decision. I've never seen an accommodation decision letter in an asylum support context which says anything about what a child's needs actually are, or never mind how they're going to be met. In relation to public sector equality duty, in context of Home Office decision letters, I don't think I've ever even seen that mentioned. There seems to be a view that because there are carve-outs to the public sector equality duty based on immigration and nationality, that it's just not relevant. But those carve-outs don't apply to disability, and they don't apply in this particular context to stop disability-related matters being taken into account. On that point, on the public sector equality duty, I just wanted to flag the homelessness case of Hackney and Hack, which I've quoted from on the next slide as being potentially relevant in the asylum support context. Now, I'm sorry if the font on this slide is a little small for some of you to make out, but what you'll immediately notice is there's quite a lot to this paragraph. These are 6 different requirements that the public sector equality duty necessitates when considering the suitability of accommodation. So it requires particular impairments of the occupant to be taken into account. It requires those to be put in the context of the accommodation, and a recognition that the person may need to be treated more favourably than a non-disabled person. That's the sort of level of detail which, in the homelessness context, the public sector equality duty requires. And I think there is a good argument that the legal framework of homelessness is similar enough to asylum support, but this is actually what we should be seeing in Home Office decision making. These sort of considerations taken into account, and I've certainly never seen anything like that level of detail. So those are our general considerations on adequacy in the asylum support context. Moving on to more specifics and starting with location. Well, we all know the default position as asylum support is dispersal. You get dispersed out of London, out of the south of England, but requests still have to be considered. If there's a request to be considered in a particular location, that still has to be taken into account. If local authority support is being provided, so this is particularly relevant to our vulnerable migrant children, then accommodation should normally be arranged close to where the support is being provided. So if they're getting either Section 17 support or education related support, then normally default position should be they should be accommodated near that. Final years where children are at particular stage, the critical stages of exams are recognised as times when they shouldn't be moved. Probably the most robust part of the policy, and sorry, just to flag, this is the allocation of accommodation policy, refers to special educational needs. Those children who have special education needs who are in appropriate schools should normally be accommodated near the school. So the default position of the Home Office of dispersing to Middlesbrough is not good enough for children who have special educational needs. There are further factors to consider in the healthcare policy, which are particularly relevant if you've got children who've got physical or mental health issues that they're receiving treatment for. As to quality of accommodation, there's not a lot in the policies that says what sort of accommodation should be, what it should look like. If you've got somebody who's got mobility problems, but it's generally got to be ground floor level access with a lift, wheelchair users have to be able to access all of the property. But aside from that, there's not a lot more about what sort of accommodation there is. There's nothing in the policies about overcrowding or anything like that. I think for those issues, we really need to look to the contractual arrangements that the Home Office have with their private providers like Serco. There are very, very detailed standards in those contracts, and I provided links saying what's the accommodation should be like, how many people could live there. So detailed requirements relating to things like mold, relating to leaks, relating to damp. And there is also standards relating to overcrowding, which are reasonably generous. These are very, very often breached. And I think that these are points which we can and should be raising with the Home Office as being relevant to their consideration of adequacy. Now, of course, we can't sue on the contract between the Home Office and Serco, but that doesn't stop these points being relevant to adequacy. That's a point which the claimants tried to raise in the Napier litigation, and it was sort of dismissed quite cursorily by Mr. Justice Linden as on the basis that a breach of the contract isn't determinative of adequacy. But I think it's still relevant, and in any event, even if it is not determinative of adequacy, it still, I think, militates towards the Home Office taking some kind of action to enforce their contract. So those are points I think are worth thinking about. Unaccompanied asylum-seeking children, we've got a very detailed statutory framework governing how and where they should be accommodated. And the framework, which is across the Children Act, the Care and Placement Regulations and the guidance, is replete with references to suitable accommodation, appropriate accommodation, accommodation that's consistent with welfare. So that's our general principles. More specifically, in relation to education, there is a statutory obligation, so far as reasonably practicable, to provide a placement which doesn't disrupt the child's education or training. And that has to be taken again together with the fact that local authority has to do an assessment and a care plan, and the assessment has to consider things like the duty to promote the child's educational achievement, and all of that has to be put in the care plan. So when you take all of that together, you have really quite a tight framework that means, I think, within these legal constraints, it's quite hard for a local authority to justify providing any kind of accommodation that undermines a child's educational achievement or disrupts their education. So we do have quite a helpful framework here. We've got other statutory obligations, which I've already alluded to, like Section 11 of the Children Act and also the corporate parenting principles. I don't think they add a great deal to this very sort of tight framework that's in the primary legislation itself, but they're worth recalling. On location, unless not reasonably practicable, accommodation has to be in the area. As I've already said, it shouldn't disrupt educational training. And in particular, local authorities really shouldn't be moving children moving children from accommodation to accommodation, if it's going to disrupt their education at Key Stage 4, that's only going to be justifiable on an absolute emergency basis. As to quality of accommodation, B&Bs, hotels, nightly lets are an absolute no-no. Policy says that shouldn't be done. For placements in unregulated settings, so that's things like foyers, or if you've got a young person who's living with a friend of a family who's been placed there under Section 20, local authority have to have specific regard to things like safety and repair of the accommodation. And then there are enhanced obligations for disabled children to identify their particular needs. That brings us on to our final category, which is failed asylum seekers and other persons with no recourse to public funds. In contrast to asylum seekers and to unaccompanied asylum seeking children, we are now dealing with a much, much looser statutory framework. There is no legislative requirement for accommodation provided to this cohort under Section 17 of the Children Act is suitable. What was said in the case of Yakini is there's sort of an implied requirement of suitability, but it's just part and parcel of the public law requirement to act reasonably, which, as we know, is not an especially onerous requirement. The rationality threshold is a difficult one to cross. And you can see that in the case law. I've given you 3 cases here, which I think are all very harsh on their facts, where the High Court has been unwilling to say that this accommodation is unsuitable. In the first example, the CTMU case, you had a mum and her kids who was in a single room of B&B for 7 months. That would be clearly unlawful if they were accommodated under Section 20, clearly unlawful if they're under mainstream homelessness legislation. But in this context, the High Court wasn't prepared to interfere, and the Court of Appeal upheld that decision. The MM case, similar. You've got a young autistic boy who needs wheelchair access to the accommodation and being placed on upper floor, maisonette, block of flats, not irrational. So that's the context of this. The bar has been set high by the courts. But I think all that really means is that if you are to bring productive challenges to the quality location of accommodation under Section 17, you're very much focused on procedural failings. Has there been an assessment of the child and family's needs? Have their circumstances changed? And if so, following that, has there been a reassessment? If the answer to either of those questions is no, that might be a way into a challenge. Has there been evidence presented, education, medical, which has been overlooked? And within the local authority's assessment under Section 17, have they had regard? Have they shown that they've had regard for the need to promote the welfare of the children, and shown that any sort of adverse decision is proportionate? So those are the sort of points you want to be thinking about with Section 17 challenges. Very little to be said on particular points relating to location quality. The best I'm ever able to find is the school transport guidance, statutory guidance, which local authorities have to have regard to, which gives suggested maximum journey times. But aside from that, there isn't much, and there really isn't anything which says much about the quality of accommodation under Section 17, which I think just emphasizes that with these groups, with failed asylum seekers, those with no recourse, you've got to be focused on the end game, which is sorting out the client's immigration status or getting their no recourse condition lifted so they can get into mainstream accommodation and that way get the stability they need to sort out their educational issues. So I think that certainly brings me to time. So I'm going to stop there, and hopefully we've got 10 minutes for questions.
We do. Thank you so much, Connor. Another really helpful and comprehensive outline of it all. We have one question I'll read out, and that is from someone. I'm a governor of a London secondary school responsible for safeguarding in the CSD. Many pupils falling into both these categories have significant mental health needs. This will be accentuated by increase of numbers of migrant children and the impact of the pandemic on the mental health of the general school community. Access to CAMS already has a very high threshold of access to their services, which we all know now, particularly over the course of the pandemic. What ability is there to challenge this for individual pupils? So do we have any takers on how best to challenge? Anyone want to make a comment? Ollie, you look as though you're about to say something.
I mean, essentially what's happening with CAMS is a disgrace, the underfunding, and meaning systemic underfunding, meaning that there is hugely long waiting lists. It's possible to bring delayed JRs, but in a socio-economic context, that is extremely difficult. it's a really difficult. I mean, I wouldn't be positive about the prospects of challenging that. I mean, Connor or Claire might have different views to me on that, but really, really tricky to challenge the systemic funding of CAMS, essentially.
Any other comments on that? I think we probably all agreed on the difficulties of it. It's just, yeah, it's just all quite overwhelming. And I think other than that, we don't have, let me see, actually, someone's put, right. Connor, I don't know whether you've seen this. We have a question. Thank you everyone for your interesting and informative presentations. Question for Connor. What sort of threshold of need would you suggest to refer to solicitors regarding families housed by the Home Office, for example? Would a family placed in an HMO with a child with mild ASD be an appropriate case to refer for a legal challenge re unsuitable accommodation? Can you see that up, Connor? You see the question?
Yeah, I can see that. Thanks, Nicola, and thanks, Katie. It's difficult to be prescriptive about what level of need. I mean, I don't. If you've got a child with mild ASD who's in a house in multiple occupation, I don't think that per se is necessarily unlawful. It's going to depend on what's actually wrong with the accommodation and how is it that how is it affecting the child's needs. So, I mean, I guess the starting point would be to find out how it's affecting their needs, get some evidence of that, whether it's medical evidence, whether it's evidence from social workers, etc., and put that to the Home Office. If that evidence isn't properly considered, then that's very likely going to be an error of law. That's the kind of point you want to be referring to solicitors. Generally, if that evidence shows that the accommodation is causing detriment to this young person's health or undermining their ability to access education, that's the kind of thing I'd potentially want the solicitor to be looking into. If there are particular problems with the accommodation, irrespective of the fact the child's got ASD, that the child is on the spectrum, then so for example, if there are breaches of the statement of requirements in the contract that I set out, that's the kind of thing that raises legal issues. So I guess those are the kind of flags I'd be looking for, but I can't say there's an exact threshold. I guess rule of thumb, if you think there is detriment to this child or there is evidence of detriment to their health, to their education, then that's probably the line you want to be referring.
If I could just jump in there, one of the things I'd say is that I've done a lot of Section 17 challenges, and I do think there is scope for, at some point, some judicial scrutiny about the suitability of Section 17 accommodation. So far, I've been unsuccessful in getting any of those cases actually before a judge, because they often settle actually at the pre-action stage by my clients getting moved. So it can be worth making referrals to solicitors. Solicitors will tell you whether or not they're able to take on the case. And the other thing I would also add is, perhaps before you refer it, is raising these concerns with the local authority in writing if you can, because sometimes you see in relation to the level of subsistence and also adequacy of accommodation that actually no one's ever told social services this isn't good enough. And so it can be quite useful to tell the local authority that, because then when they fail to consider it, that kind of feeds into the procedural point that Connor was saying, that you can say, well, you've not even thought about these things. So that's all I wanted to add.
Thank you. Anyone else? We've got another comment, and I think that's it. I don't think we have any other questions. From Daniel Rosenberg, highlighting the possibility of seeking or threatening damages on Article 2 Protocol Right to Education, Protocol 1 basis, when children who've come over from abroad are not being sorted out with education when the local authority is aware, can concentrate minds. So thank you for that. I see lots of nodding. Everyone in agreement. Is anyone? I think Ollie, you're muted.
Oh, sorry, am I unmuted now? Just to flag that I think the pre-action protocol process, which I think Claire made particular good reference to, can generally be a really useful way of focusing minds when they're fairly straightforward breaches, like complex breaches and the complex issues too, like the ones Claire was mentioning. But when just like EHC provision is not being put in place, or unreasonable delay in EHC needs assessment, a PAP can sort these things out quite quickly. And hopefully one of the aims of the School Inclusion Project is so that we can connect frontline people, advisors with legal aid lawyers who can get a PAP out relatively quickly and deal with these issues to avoid unreasonable delay and just like basic breaches where people think they can get away with it because there's like complete impunity because of lack of access to lawyers. Yeah. And the extent of the breaches that are going on is just about just firefighting all the time to deal with them. So I think in that case, I think those are all our comments and our questions. And we've come now to the end of the webinar. So it leaves me to thank you all very much for your excellent contributions. And hopefully with all of that on board, we can increase our challenges and successes, improving access for migrant children. So thank you all. Hope you all have a very good evening, and I'll now end this webinar. Thank you. Bye-bye.